Judgment in the appeal, CNN, Times Newspapers Limited and others.
Who's giving it? Lord Sumption will give the judgment to the court.
An anonymity order was made at the outset of the hearing in this case. By consent, that order is now lifted with immediate effect, with the result that there are now no restrictions on the disclosure of the identity of the appellant. The appeal is the latest chapter in the long-running contest between the freedom of the press and the right to private and family life. Both of them are fundamental values in our society, protected by the European Human Rights Convention, but they are frequently in conflict. The background to the appeal is the trial of 9 men at the Old Bailey in 2013 on exceptionally serious charges involving organised sex grooming and child prostitution in the Oxford area over a period of some 8 years. 7 of the 9 defendants were convicted and received substantial sentences of imprisonment. They had originally been arrested by Thames Valley Police in March 2012 after a long investigation known as Operation Bullfinch. Mr. Tariq Khuja, who has up to now been referred to in these proceedings as PNM, was arrested at about the same time as the 9 and was released on bail on terms that he surrender his passport. The reason for his arrest was that one of the victims of the child prostitution ring had told the police that she had been sexually abused by a man with the same first name. It is, however, a very common first name, and the victim failed to pick him out at an identity parade. During the trial of the 9 accused, Mr. Khuja's arrest and bail terms were referred to, and his possible involvement in the offences was raised on a number of occasions in the course of the evidence and counsel's closing speeches to the jury, as well as the judge's summing up. He was referred to in each case by his full name. Initially, publication was prevented by an injunction made by the trial judge, His Honour Judge Rook. Judge Rook made an order on Mr. Khuja's application temporarily forbidding the publication of any information which might identify him as the person referred to as Tariq by the victim. Mr. Khuja's arrest and bail terms were once more referred to in the course of his application. All this took place in open court. Judge Rook made the order which Mr. Khuja sought on the ground that while he was on bail, the publication of his name was liable to prejudice any future criminal proceedings against him. However, shortly after the end of the trial, he was released from arrest without charge by the police. That changed the situation because there was now no real likelihood of a trial which might be prejudiced by the disclosure of his position and no basis for continuing the injunction. For that reason, Judge Rook eventually ruled that his injunction should be lifted. However, before the ruling could be put into effect, Mr. Khuja moved the battle to the High Court. He applied for an injunction there on a different ground, namely that an injunction was necessary for the protection of his right to private and family life under Article 8 of the Human Rights Convention. After hearing argument, Mr. Justice Tugendhat refused to grant the injunction. The Court of Appeal affirmed his decision. Today, by a majority of 5-2, the Supreme Court holds that the courts were right to refuse the injunction for reasons set out in a judgment which I have prepared. The Times and the Oxford Mail have taken a close interest in investigating and reporting on allegations that the police and social services have failed adequately to deal with a pattern of crime involving the sexual exploitation of young teenage girls by older men. They covered the Old Bailey trial in detail. They wished to publish information derived from the proceedings at the trial, identifying Mr. Khuja as someone who was suspected of involvement in the Oxford child prostitution ring and who had been arrested and then de-arrested in the course of Operation Bullfinch. If they publish that material, they will be protected from liability for libel by the rule which confers absolute immunity on fair, accurate, and contemporaneous reports of legal proceedings. Mr. Khuja's case is very straightforward. He has never been charged, let alone convicted, of any offence connected with the Oxford child prostitution ring, and there is no present reason to believe that he ever will be. He is, as matters stand, an innocent man. But there is no doubt that there is a real risk that many people, knowing what was said about him at the Old Bailey trial, would conclude that he was the person called Tariq, whom the victim said had sexually abused her. Never having been charged with an offence, he has no means of clearing his name in a criminal court, and the absolute privilege attaching to reports of legal proceedings means that he cannot vindicate his reputation in civil proceedings either. The publication of references to him at the Old Bailey trial is therefore likely to cause serious injustice to him and will be particularly hard on his family. The essential reason why the injunction must nevertheless be refused is that it is a cardinal principle of the administration of justice in this country that it is openly administered in public proceedings which any person may attend up to the limit of the courtroom's capacity. Proceedings in court are public acts of the state, and as such open to public scrutiny. The press acts as an extension of the courtroom, as the eyes and ears of the public who would have been entitled to be there, but are unable or unwilling to attend in person. There are exceptions to this principle, but they are narrowly confined. They relate mainly to cases where non-disclosure is necessary in order to protect the administration of justice itself, or where it is necessary to protect the position of minors and other specially vulnerable groups. They do not apply to people in the position of Mr. Khuja. Mr. Khuja has no right of privacy in respect of what was said about him in a public forum. The only basis on which he could contend that his right to private and family life had been invaded is the impact that disclosure would have on his relations with his family. That impact may well be serious, as the court recognizes, but it is both indirect and incidental. In the nature of things, what is said in court in the course of criminal or civil proceedings may indirectly and incidentally affect third parties who are not directly involved. It may be misleading or untrue. It may be intensely private, profoundly embarrassing, extremely hurtful or discreditable. The law protects those who participate in court proceedings, the judge, counsel, witnesses, and others, from civil liability for what they say, in order to enable them to perform their important roles in the administration of justice. The law protects those who report what has been said and done at a public hearing in the interests of open justice. It is an unfortunate but inevitable fact that innocent people may suffer collateral damage as a result, but it is part of the price that we pay for a transparent system of public justice.